Today I'm going to talk about the exclusionary rule and why we should abolish it. Let me start with the two instances where I believe a true exclusionary rule may apply. First, if testimony or evidence is so misleading that a judge or jury could be swayed to the point that they cannot fairly evaluate the testimony or evidence on its face value. In other words, testimony that is so derogatory or false, its sole introduction is simply to sway the judge or jury from the truth. Second is certain social relationships that are core to our belief system. Privacy privileges need to be protected. Privileges such as client-lawyer, doctor-patient, husband and wife. That being said, the structure of our Constitution advocates for truth-seeking procedures. While it's true that the Fourth Amendment deals with illegal search and seizures, it does not include the exclusionary rule as a remedy or deterrent for unconstitutional searches and seizures. In fact, the Fourth Amendment does not distinguish between criminal and civil courts. However, the exclusionary rule only applies to criminal courts. If legally found evidence was a true privacy violation, exclusion would apply in civil cases as well. The Fifth Amendment, to protect the self-incrimination, is not a pure privacy privilege itself, in that immunity cannot be offered in place in order to garnish the testimony that does in fact incriminate oneself. The Fifth Amendment also is only applicable to criminal cases. The courts have also ruled that the Fifth Amendment only applies to testimony. Thus, a person can be compelled to give blood or DNA that they know to be self-incriminating. So the Fifth Amendment does not apply to evidence that might fall under today's exclusionary rule. In England and other countries with systems based on truthful integrity recognize this fact, and such do not recognize the exclusionary rule. They do not withhold evidence because withholding evidence denies the facts both at trial itself and also the public the courts serve. While excluding truth from trials, there will be two types of system errors: wrongful convictions and wrongful acquittals. The exclusionary rule was intended to deter police from illegal search and seizures, but many things that are created for good, the exclusionary rule now benefits the guilty by excluding evidence wrongfully seized. Thus, the exclusionary rule is no longer protecting the public through deterrence, but is harming the public through wrongful acquittals and denying them the facts of the case. Therefore, we should abolish the exclusionary rule as a form of deterrence and set other guidelines for deterrence of illegal search and seizure. If an illegal search and seizure is conducted, there could be laws that carry punitive measures, or they could levy fines or damages, or even use civil litigation could be deterrence. It would be then, in the least, a budgetary concern for the police, which could be the driving deterrence and not the fact that the guilty person is going free, harming the public more.